Hi there. Good morning, good afternoon, good evening, whatever time it is. As always, happy whatever day it is that you are watching this. This is What's Left. I'm your host. My name's Larry Erickson. And for the next close to half an hour, I'm going to be talking about a couple of things, maybe some things you're expecting me to talk about, maybe not. But I hope you'll find them interesting enough to stay with us for that time. As always, if you have any questions, comments, or reactions to the show, this is my personal email here, whoviating@aol.com. And you can just send me an email. If you do, please be sure to include something in the subject line that makes it clear it's not spam, it's about the show, and be a little patient about getting an answer. Or if you don't want to go that route, you can go to my website, which is called Lotus Surviving a Dark Time, and the URL will be over here a couple of times during the show. And you can get the email address from there if you didn't write it down now, or you can leave a comment there if you'd rather do it that way. All right, with that, let's get on with it. Starting, as I like to when I can, with some good news. This first bit of good news requires some explanation, requires some background. Lexmark, you've probably heard of them. They're a company that makes things like printers and printer cartridges and so on. It makes two kinds of printer cartridges, though. An expensive reusable model and a cheap single-use model. The only mechanical difference between these two cartridges is that the cheap model has a chip in it that disables it after a single use. Now, Impression Products is one of several companies that collected these cartridges, disabled the chip, and refilled them, and then sold them for less than Lexmark charged. Lexmark sued for patent infringement. They sued Impression's product in 2013. Now, various courts split on the issues involved, so it wound up at the Supreme Court. On May 30th, the Supreme Court struck a blow for consumers and for independent repair businesses and against corporate domination, voting by 7-1 to tell Lexmark that I told them flat out, in fact, in literally so many words, that its patent rights over one of these cartridges ended. Legally, the term is were exhausted when that cartridge was sold. That is, Lexmark can prevent anyone else from making a cartridge of the same design, but once it sells it to you, it can control what you do with it, including having some third party refill it. Now, other than the fact that this can reduce the cost of printer ink, which is something I think would be a relief to a lot of us, the real point is that the case actually is about ownership rights, about your control over a product that you have purchased. Writing at Wired.com, Kylie Weens writes, and I'm quoting him here, "Consider this. Countless people hack their Keurig machines to brew unauthorized coffee brands. Could Keurig sue them? Could Apple or Samsung stipulate that you can't resell their products on Craigslist or eBay? Could John Deere claim that a repair tech is infringing upon its patent rights by repairing a broken combine without its permission?" The point is, by Lexmark's position, the answer to all of those questions is yes. The effect of the Supreme Court's decision is to say that the answer to all of those questions is no. Now, the court can be aware of the effect, the broader sense that this decision has, the broader effect it can have, can be seen in the fact that John Roberts, writing for the majority, cited a hypothetical shop that restores and sells used cars as an example of business that could not run at all if manufacturers could put restrictions, post-sale restrictions on their products, the way Lexmark had tried to do with its ink cartridges. So not only Impression's products, but every independent repair shop and repair business can breathe easier. This, of course, because all good news comes with bad news these days, it seems. This is not the end of it. Companies will likely start doing what John Deere did after losing a copyright lawsuit. You update your end user license agreement, your EULA, to try to accomplish by contract what they can't accomplish by patent law. Lexmark, for example, also made consumers sign a post-sale restriction contract stipulating that only Lexmark could collect, refill, and resell the ink cartridges. At the same time, though, that kind of thing is much harder to enforce because you have to sue the individual consumer, not the company, because the company had no contract with Lexmark. Now, in a closely related note to this, 8 states, Kansas, Wyoming, Illinois, Massachusetts, Minnesota, Nebraska, New York, and Tennessee, are this year considering so-called right-to-repair laws. Lobbyists have already effectively killed one of them. The one in Nebraska was tabled. But I doubt that even in Nebraska, this is going to come up again. So Goliath is not down, but David still has some stones. As a quick final note to this, what this means, by the way, notice, is that Impressions Products could gather a Lexmark cartridge, disable the chip, refill it with ink, do all of that, and still sell it for less than Lexmark charged in the first place. It's an illustration of the power of control and the power of market domination and reason to challenge it. All right, we got also some good news on, well, I should say this is prospective good news. If this works out the way some people are predicting, it will be very good news. The Supreme Court has announced that it is going to review a case called U.S. v. Carpenter, a case involving long-term retroactive tracking of a person's movements by using information generated by their cell phone. The Electronic Frontier Foundation called this exciting news in the world of digital privacy. The case involves 2 defendants, Timothy Carpenter and Timothy Sanders, convicted of a string of armed robberies in 2011. The issue at hand is that the prosecution won the convictions, at least in part, by convincing the jury that the 2 were at the scene of each of the robberies by using the cell site locator information, the CSLI data for each of their cell phones for some months around the time of the robberies. Records that the FBI obtained from the cell phone companies involved without a warrant. The pair contended that such warrantless searches were a violation of their Fourth Amendment rights, but the Sixth Circuit Court of Appeals rejected that argument. So the case has now been accepted by the Supreme Court. The Sixth Circuit Court said that the information from the CSLI records was merely information necessary to convey a call rather than the content of the call. So access to those records was not a search under the Fourth Amendment, ignoring the fact that those same records, which were not a search, could also reveal where you were, when you were there, and how long you were there, which was precisely the info that was used to convict the Carpenters. The Electronic Frontier Foundation said that the Sixth Circuit Court's ruling, quote, shows a complete disregard for the sensitive and revealing nature of cell site locator information, as well as equating analog technologies that were involved in older court cases with what, again, the Foundation calls the data-rich technologies of today. In other words, the court didn't know what it was talking about with regard to the technology, so in effect fell back on sure cops, whatever you say. Which is one reason why the EFF, the Electronic Frontier Foundation, wanted the Supreme Court to take up the case, especially in light of the fact that the court has twice recently heard cases involving digital privacy, and in both times ruled against the police and in favor of privacy. There is a reasonable hope that the Supreme Court, which seems to be more aware of the technological issues involved than some of the lower courts there is a reasonable hope that the court will rule that way again, and that would be good news. There's a footnote to this. It is also hoped that the court will use this opportunity to revisit and, from my perspective, hopefully reverse the so-called third-party doctrine, a, to me, bizarre legal principle derived from two 1970 Supreme Court decisions. The principle holds that information that you voluntarily share with someone else, whether that someone else is your bank regarding, your account information and so on, or your phone company, referring to, for example, the numbers that you called, or a government informant, or anybody else, that any information you voluntarily share with a third party isn't protected by the Fourth Amendment on the grounds that you had no basis for assuming that they would keep it secret. Ultimately, what this means, this principle means, is that in the absence of specific legal protections, such as lawyer-client or doctor-patient confidentiality, or in the absence of perhaps some binding legal contract with that third party, the government is entitled to know anything you tell anybody. Your only true legal privacy lies in information and thoughts which you never share with anybody. I've always found this notion offensive and absurd. I mean, I first heard about it when these cases were resolved in the 70s, and I always found it more the logic of a police state than a free one, and it's even more absurd and dangerous now. Because as Sonia Sotomayor said back in 2012 on another Supreme Court decision, the third-party doctrine is, quoting her, ill-suited to the digital age in which people reveal a great deal of information about themselves to third parties in the course of carrying out mundane tasks. And she also said, which I think is really important, it's time to stop treating secrecy as a prerequisite for privacy. Again, there are recent cases that give some reason, at least, to hope that the Supreme Court will move from 1977 to 2017. And if that happens, that would be good news. On the other hand, it seems these days that no good news goes unblighted by not good news. So speaking of privacy, the reactionaries in Congress and the White House want to set in stone a law that essentially allows the NSA to spy on Americans. The issue is Section 702 of the Foreign Intelligence Surveillance Act, FISA. It has a sunset provision, which means that every few years it will expire unless Congress reauthorizes it. It is set to expire on December 31st of this year. Now, the reactionaries don't want to just reauthorize it. They want to make it a permanent law. Section 702 is the provision that allows the NSA to sink its hooks directly into the physical infrastructure of the Internet, going to ISPs, Internet Service Providers, and going right to their data stream and sucking up all the Internet traffic passing through that point. Email, Skype chats, videos, Facebook messages, web browsing history, all of it. Anything and everything, whether public or not. And remember, this kind of thing includes the actual content. The purpose, we're told, is to enable the spooks to collect the digital communications of foreigners believed to be living outside the United States because, never Americans, no, and never inside the U.S., no. See, the NSA is not supposed to, quote, intentionally target any U.S. citizen, any other U.S. person, or anyone located within the United States. And of course, just like Brutus, all the folks at the NSA are honorable people. But even engaging in that particular fantasy, the words intentionally and target have been given such wide and, let's just call it, flexible meanings that millions of Internet records of millions of Americans are unintentionally swept up and cataloged. But don't worry, the NSA insists it does not collect any records on any Americans until you learn that in the NSA's version of English, a record isn't collected until an agent actually physically looks at that record. That record can be gathered, indexed, and permanently stored, but it hasn't been collected. And now the gangsters in Congress and the White House want to make this a permanent feature of U.S. law, relieving themselves even of the burden of the occasional charade of having to pretend that they're actually concerned over its merits. Personally, I consider this a deal breaker. If either of your senators or your rep votes for this, does not in fact actively oppose this, they do not deserve to be in office. And I don't care a flying damn about, but look at the good they do with this other thing, arguments. All right, on something else, something else I've been wanting to bring up, just because, hey, it's my show, so why not? A couple of weeks ago, I celebrated the fact that Chelsea Manning had been released from prison. At the time, the only image I had of her was a selfie of her in a wig. An image I've since learned was never supposed to have been circulated. It was sent privately by her to her counselor and her to her therapist and her commanding officer, but somehow it got out and got circulated to what everybody knew. So it was never supposed to have been circulated. Anyway, I wanted to note that now we have this one. This is Chelsea Manning in her first photos as a free transgender woman. Unavoidably intertwined with Manning's case is that of Julian Assange, director of WikiLeaks, an organization that the Obama administration tried to bankrupt by blocking any access to any source of funding. The Department of Justice, the DOJ, tried every way it could to think of to find something they could charge Assange with that did not also implicate major publications like the New York Times and the Washington Post, which published portions of the documents that WikiLeaks obtained and released. And the truth is, there is simply no rational question but that the highly harsh treatment meted out against Chelsea Manning, including extended solitary confinement, and the massive and threatening charges filed against her, were an attempt to force Manning to finger Assange as having either induced or better yet directed her to copy and send him these files, giving the U.S. a way to get Assange without having to worry about little things like freedom of the press. When they couldn't break her, they were left without a case against Assange. But that didn't mean they gave up trying. And now, after 7 years of effort, according to reports, they think they have found a way to get Julian Assange. And Attorney General Jeff Too Races to Be a Judge Sessions said recently that getting Assange is a priority. Meanwhile, in one of those moments of deliciously overt hypocrisy, CIA Director Mike Pompeo has labeled WikiLeaks a non-state hostile intelligence service, often abetted by state actors like Russia, and proclaimed that we can no longer allow Assange and his colleagues the latitude to use free speech values against us, while calling Assange himself a fraud, a coward, and a narcissist. This is the same Mike Pompeo who last July gloated over the DNC emails released by WikiLeaks, calling them, and this is a quote, proof that the fix was in from President Obama on down, and who during the fall campaign repeatedly referred to those emails in order to attack Hillary Clinton. And on a final note on this, for now at least, Sweden has dropped its fishy from the start investigation of Assange, an investigation that, contrary to the impression you no doubt got from the media, never involved an actual charge. Supposedly, he was only wanted for questioning, and the Swedish prosecutors have now said they are giving it up because there is no way they can be able to question him, even though he has previously offered to be questioned in the Ecuadorian embassy, where he has been given asylum. He has offered to do it by video conference. He even offered to go back to Sweden if the Swedish government would offer guarantees that he would not be extradited to the United States. Sweden refused every offer. The UK, for its part, still says Assange, the Ecuadorian embassy I'm talking about is in London, and the UK still says that Assange will be arrested the instant he steps out of the door. He'll be arrested on a charge of missing a court date. Like Sweden, The UK will give no assurance that if he gives himself up, he will not be immediately bundled off to the US to face whatever charge the DOJ can conjure up in the hopes of destroying him and WikiLeaks along with him. And with that, we are going to take a break. And we're back. We're back actually with a sort of update on a topic I talked about last week and talked about several times, voter rights, voter ID in particular. Last week, in fact, I described how on May 15th, the Supreme Court had finally slammed the door on North Carolina's attempts to restrict the votes of minorities through voter ID laws. Well, guess what? On June 4th, North Carolina got smacked down again by the Supreme Court, as that court upheld a lower court decision that 28 of the state's legislative districts were illegal racial gerrymanders intended to dilute the impact of black voters. One example was District 21, where the Gopper-dominated legislature, which of course drew the lines, took a district that had a plurality of black voters and changed it into one with a majority of black voters. Now, the state rather feebly claimed that it had to do this under the Voting Rights Act to make sure that black voters could elect had a chance to elect the candidate of their choice. But the point is that in those plurality minority districts, they were already electing candidates of their choice, generally black Democrats. So the effect of the change is not to enfranchise minorities in any district, but to make the surrounding districts whiter and thereby reducing the impact of the voting power of any minorities in those surrounding districts. Happily, both the Circuit and the Supreme Court saw through the state charade, and new districts will have to be drawn. This actually comes on top of a decision by the Supreme Court in May that 2 of North Carolina's congressional districts were also illegal racial gerrymanders. The record seems to show that the North Carolina Goppers have figured out that the only way they can keep winning is by cheating. On a less happy note, Texas has enacted what's being described as a more relaxed version of a voter ID law that got shot down by U.S. courts as racially discriminatory. Voters still have to produce some kind of ID at the polls, but the types have been broadened to include something like a bank statement or a utility bill that shows their name and address, provided that they will also sign an affidavit attesting to having a reasonable impediment to obtaining a photo ID. That is, if they're willing to sign this affidavit after, very likely, having been told that lying on such an affidavit carries a penalty of up to 10 years in prison, and provided they're absolutely clear in their minds that whatever their problem is, it would constitute a reasonable impediment under the law. By the way, the list of valid photo IDs has not changed. It includes a driver's license, a U.S. military identification, a U.S. passport, and a concealed handgun permit, but not, interestingly, a student ID card. All right, next up, this is an occasional feature. It's something where sometimes you just gotta laugh. There's just no other option. TheRump's private attorney, Mark Kasowitz, said his orangeness felt completely and totally vindicated by James Comey's opening statement to the Senate Intelligence Committee because it included references to 3 occasions where he told TheRump that he wasn't the subject of an FBI counterintelligence investigation about possible Russian meddling in the 2016 election. Of course, that same statement also described a dinner where TheRump asked Comey if he wanted to stay on FBI director and then said, "I need loyalty, I expect loyalty." At a meeting a couple of weeks later, when he told Comey, referring to then National Security Advisor Michael Flynn, quote, "I hope you can see your way clear to letting this go, to let Flynn go," which together constitutes classic obstruction of justice. But don't worry, TheRump surely now hears that many people say that he is totally vindicated. Next up, one of our regular features, this is the Clown Award. And one example this week blew away the others so efficiently that only celebrity forensic psychiatrist Park Dietz, who said that, quote, "there are now benefits to being a sexual assault survivor," And Laird Wilcox, author of Crying Wolf, who insists that 80% of hate crimes that occur on college campuses are hoaxes or pranks, they're the only ones that even made the cut. So this week, the winner of the Big Red Nose is Commerce Secretary Wilbur Ross. Just over a week ago, he appeared on CNBC to discuss TheRump's trip to Saudi Arabia. He talked for a few seconds about some venture capital thing that he attended. But you know what really got him going? What he really almost gushed about? Quoting him, I think the other thing that was fascinating to me, there was not a single hint of a protester there any time during the whole time we were there. Not one guy with a bad placard. When the host interrupted to suggest that maybe that was true because Saudi Arabia is, a dictatorship, although she put that rather more delicately, Ross allowed us how, in theory, that could be true, but quoting again, boy, there was certainly no sign of it, that is protest. There was not a single effort at any incursion. There wasn't anything. The mood was genuinely good. And he wrapped up by recalling how Saudi security guards gave him 2 bushels of dates as a going-away present. Now that is just so stunning in its utter cluelessness, its astounding disconnect from the world around him, that it almost makes you pity him, until you remember that Wilbur Ross is also the man who last month described news of the U.S. cruise missile attack on a Syrian airfield as in lieu of after-dinner entertainment, marking him not as clueless, but as cold-bloodedly ruthless and indifferent to the oppression of others. So instead of giving Wilbur Ross a red nose, we're going to give him the full makeup job he deserves, befitting his status as not just a clown, but an evil clown. All right, last up, the outrage of the week. You're probably not surprised, coming from me, that the outrage of the week this week is TheRump withdrawing the U.S. from the Paris Climate Agreement in a statement chock full of nonsense and lies about the environment, and a decision that was actually opposed by the American public by better than 2-1. But rather than dwell on his inanity, I just wanted to note 2 things. One is that much of the world reacted pretty much along the lines of, the heck with you, and no, we are not going to renegotiate this thing. And that domestically, many local governments are prepared to pick up the ball that TheRump fumbled so badly. There's a growing list of, at last count, 211 mayors and 10 governors who denounced the decision to withdraw and, more importantly, have vowed to ignore TheRump's decision and to continue to abide by the accord, trying to meet its goals in their own cities and states. 3 states, Washington, New York, and California, have created the United States Climate Alliance to serve as a way for states to coordinate efforts to deal with climate change. As a sign of what can be done, those 3 states together make up about 1/5 of the U.S. population, 1/5 of the U.S. economy, but only produced 11% of its emissions. So the bottom line is that most of the world, and at least a good part of the U.S., are saying to TheRump, screw you, keep peddling your fantasies about coal jobs that are never coming back, and we'll get on with the business of saving the world. And that is definitely not an outrage. All right, so that's it for this week. Hopefully we'll be back next week with more stuff, more good stuff. But for the moment, you have the best week you possibly can. As always, peace.